this date was mutually taken on the 12th of May 2025 after this court rendered a ruling on the accused application to be admitted to bond. The early date was taken following my direction contained in the ruling. It would not add restating the relevant direction in this ruling. The relevant direction was as follows, quote, that due to the public interest that the case has elicited, I direct that the case be listed on priority basis and where possible be heard on a day-to-day basis, end of quote. After the delivery of the ruling, this is what Mr. Callisto stated to the court. Quote, I have received the prosecution witness statements and documents. We can take a hearing date, end of quote. To the best of my recollection, there was extensive consultation before this date was mutually settled on. Each party considered the date a convenient and available for the slated hearing. Mr. Callisto this morning informed the court that he was not ready to proceed, not just himself, but also his fellow counsel, Mr. Mbarak. In two applications, they sought to have the matter adjourned. Mr. Callisto submitted that inasmuch as he received the documents from the prosecution, the documents received did not consist of some crucial documents referred to by the witnesses. Without making reference to a particular witness, he singled out investigation diary from the time a case of missing person was reported via OB 2319/1/2025 until the point the accused persons were arrested. He also called for a letter by the DCIO calling to be furnished with work tickets with specific reference to tickets serial number 262121 and 26223 and the duty rosters of 18th of January 2025 as they doubt the authenticity of the documents applied to them in that respect. He anchored this application under Article 52J of the Constitution. Mr. Mbarak, in advancing the second application, which he considered it a preliminary objection, and which in his own words directed that the court must make a determination on, submitted that the communication data of Brian Odhiambo and the six accused persons were procured contrary to Section 118 and 121 of the Criminal Procedure Code. Since no such warrant was requested and obtained before the same were extracted, that the call logs sought to be relied on fell short of provisions of Section 106 and 107 of the Evidence Act, and finally that they doubt the authenticity of the electronic documents supplied as they do not bear the QR code or stamp of Safaricom Limited. Ms. Sang, appearing for the prosecution, presented a straight and concise response to the two applications as follows. 1. That they supplied all the documents in their possession to the defense. 2. That they do not intend to rely on the identification parade, and the four witnesses present today do not make reference to the say ID parade forms. 3. That Mr. Mbarak's application and/or objection and/or preliminary objection is premature and which is in a form of objection that can only be raised at trial. The above objections were amplified by Mr. Abuya, Mr. Kipkoech, and Mr. Yegon, whose responses in furtherance were as follows. 1. That nothing has been produced, and that there is no record yet capable of being expunged as sought by Mr. Mbarak. 2. That the objection presents a vivid demonstration of how KWS is conflicted in this matter. 3. That the application is without basis, as the defense cannot seek to create imaginary documents and insist on being supplied to them. 4. That the application purport to speculate way before trial the documents sought to be relied on by the prosecution and raise objection way before dawn of the trial. The defense reiterated their application on rejoinder. This is my determination. May I affirm that I am alive to the provision of Article 52J of the Constitution, which the application revolves on. For clarity, I reproduce the same, and it is as follows. Quote, every accused person has the right to a fair trial, which includes the right to be informed in advance the evidence the prosecution intends to rely on and to have reasonable access to that evidence. End of quote. Have the prosecution lived to that mandatory constitutional expectation? It is not in doubt that the prosecution has supplied all the documents they intend to rely on. This is affirmed by Ms. Sang's submissions. What the defense contends is that beside what has been supplied, there are documents that witness statements make reference to that were not supplied, including the OB extract of OB number 23 of 19th January 2025. The prosecution is constitutionally mandated to supply or make available to the accused the evidence the prosecution seek or intend to rely on at the trial. What the learned prosecutor has supplied is evidence that they intend to rely on, hence meets the constitutional threshold provided for under Article 52J referred above. If there are further documents that and information the defense seek, they still reserve the right to obtain such evidence, and such request ought to be placed. The defense in this case have not provided any such request of information beyond that which the prosecution intend to rely on. Waiting to the hearing date is a clear scheme to scuttle the hearing of the matter. I have also bothered to look at the documents referred to by the defense. One is the OB extract, which is available and a public document, and secondly, a letter to KWS, which is its own institution, which they seeking to authenticate its own documents. A further indication has been put forth and not contested that witnesses lined up today do not make reference to those documents. This is a clear indication that no prejudice shall be suffered should the matter proceed. The second limb of documentation that is with reference to the authenticity of the question is a question that can be dealt with at trial. No prejudice too shall be suffered. On the second application, which I do not wish to spend so much time on, is the issue of the evidence the prosecution On the second application, which I do not wish to spend so much time on, is the issue of the evidence in the prosecution's possession. The nature of the application is which can be dealt with at the trial and at the production. Sorry, there is an issue here. On the second application, which I do not intend to spend so much time on, is the issue of the evidence in the prosecution's possession. The nature of the application is which is to be dealt with at the trial, and that no document has yet been produced before this court. The application first does not stand the test of what constitutes a preliminary objection, and second is that the application is premature, as nothing has been produced before this court, and as rightly observed, capable of being expunged from the court record. The two applications with respect fail. The defense is at liberty to place their request for the documents on the prosecution. In the end, I do not find sufficient cause to adjourn this matter and direct that the matter proceeds for hearing as scheduled.